The controversial Computer Misuse and Cybercrimes Amendment Act 2025 has been temporarily suspended pending the hearing and determination of a petition challenging it. High Court Judge Lawrence Mugambi issued the conservatory orders Wednesday afternoon as another petition challenging the amended laws was filed. The suspension of the enforcement of the law comes as religious leaders join in the condemnation of the laws deemed to be oppressive and unconstitutional, as the government defended both the timing and the signing of the laws by the president and the impact on the same. Enjoyed by Kenyans. Here's Brenda Wanga with the details of that report.
Exactly a week after the controversial Computer Misuse and Cybercrimes Amendment Act was assented to by President William Ruto, the High Court has stopped the enforcement of sections of the law. The petitioners in the case moved to court under a certificate of urgency, arguing the new law is unconstitutional, null and void, as it infringes on the rights to privacy, freedom of expression, access to information, and fair administrative action. The petitioners contend that the law introduces vague and overbroad provisions that criminalize online expression and weaken Kenya's Data Protection Act of 2019. Justice Lawrence Mugambi suspended the enforcement, implementation, and operation of Section 27(1)(b), (c), and 2 of the Computer Misuse and Cybercrimes Amendment Act 2025. The petition filed by Kenya Human Rights Commission and Reuben Kigame accuses Parliament of procedural impropriety, arguing that the bill should have been treated as one concerning county governments under Article 110 of the Constitution. The suspension came as religious leaders faulted the president for assenting to the law, which they said was a direct assault on critical voices, especially among the youth who dominate Kenya's digital space. The Church and Clergy Association in a statement had termed the Computer Misuse and Cybercrimes Act punitive, oppressive and unconstitutional and done in bad faith. The association says it was mischievous of Parliament and the government to impose punitive fines and jail terms that are meant to crack down on divergent views. Key provisions, including expanded powers for government agencies to block online content deemed false or mischievous without judicial oversight, and the requirement for social media account verification, are what the religious leaders called the hallmarks of digital dictatorship. Equally controversial for the leaders is the new Privatization Act, where the government argues it will streamline the sale of non-performing state corporations to boost the economy. Critics warn it strips Parliament of its fundamental oversight role. A section of MPs are justifying the president's actions as necessary and time-bound.
That the signing of the bills on that particular day was not a political maneuver nor an act of insensitivity during a period of national mourning. Rather, it was a constitutional obligation that had to be fulfilled within the legally prescribed time frame. The timing was purely coincidental for the 14-day deadline. It so happened to have also fallen on the same day that we lost our beloved Prime Minister, former Right Honorable Raila Amolo Odinga. So it was purely a coincidence.
The government, however, remains defiant, terming the new tougher measures contained in the newly enacted laws as necessary to prevent harmful online behavior. Interior PS Dr. Raymond Amolo also urged the public to shun what he terms as misleading and inaccurate information posted online and instead read the actual contents of the amended law. A second major petition has been filed against the act. Petitioner Francis Awino in his petition says the amended law not only introduced oppressive and unconstitutional provisions that criminalize online speech, but also infringed on the public's freedom of expression, media freedom, and other rights protected in Articles 33, 34, 47, and 50 of the Constitution. Brenda Wanga, Citizen TV.